The warnings for these drugs, prescription drugs, don't go to you and me. They go to the doctor. That's where it stops. The doctor is the one that has to fill that prescription, or you can't have it. So the warnings are not, oh, I wasn't personally warned. No. It's going to be the doctor. Did the doctor know? And we depose that doctor if he says, hey, even knowing what we know now, I still would have given her the drugs, or him or her the drug, because I still think it benefits her. That could be the end of your case.
Welcome to the Law Talk Podcast, where we take you behind the curtains of a successful personal injury law firm. This season, the Hollis Wright team of attorneys will discuss a lot of topics sure to be pertinent to you and your family. You'll hear about current events as well as Alabama legislation impacting the legal industry and you. You'll hear about steps involved in a personal injury case and even hear an exciting case study involving a client, his injuries, and his ultimate success. You'll hear how the work performed by the attorneys at Hollis Wright and in the legal field helps to keep corporate America in check. Before we dive in, a little background. Hollis Wright & Clay is a law firm located in Birmingham, Alabama, with 10 seasoned trial lawyers on staff, a firm built on experience, excellence, and decades of incredible results. Mass torts, our topic of conversation with the one, the only, Bell, how are you?
I'm doing very well. How about yourself?
I'm doing well. Now, before we get to the matter at hand, other than Josh Wright, is it true you've been with Hollis Wright longer than anyone here?
This is true. So
you're a senior member of this team. Does that make you feel old?
It does make me feel old.
You look great, though. So obviously you're living
16 years, I think.
16.
Yes.
Well,
long
congratulations.
Time. Thank you.
Congratulations. You've seen things. You've got. You have seen things.
Absolutely.
You are quite the pro when it comes to mass torts. This is your. You and I have had many conversations on the attorneys on the television show back when I was doing that. Mm-hmm. So it seems perfect that we're back here on this. So first of all, the term mass tort. So help us understand, what is that? That sounds like a goofy lawyer phrase to me.
Yeah, I get that. Basically, you're talking about, it's a civil lawsuit, but it's going to be a large number of people who have been injured by, say, one company or multiple companies, and all the injuries are similar, about the same. Just quick example, you see these commercials on TV for hernia mesh. There are multiple hernia mesh manufacturers, and some of these products are hurting people. So you'll have thousands of people. I think there's 25,000 still filed right now in that case. So 25,000 people are claiming they were hurt by this product. They all bring a lawsuit against this manufacturer. And that's what a mass tort is where you have all these people bringing a claim against one or two companies for same or similar type of instance. Totally different than a class action.
But now that's interesting, because it's almost as if in public and with lay people, mass torts and class action is the same thing, but they are not the same.
They're not. And I would say it's not just public and lay people. Have attorneys who refer us cases, and they're like, hey, I heard you're involved in this class.
Right.
So if you don't do this type of work, you will think class. But class is totally different. Class is what's going to happen is, a good example is what we're seeing a lot now is these data breaches. AT&T and 23andMe and all this. So what will happen is a group of attorneys will sue those companies for the fact that they were very lax with their security. And a court will come in and certify the class, which is everyone who was, compromised, and they'll pick one person to be the class rep. So you only have one individual. Where in mass tort, again, there's multiple individuals have their own individual lawsuit. It's just same or similar against the one, where this is one person represents the whole.
Right.
And that's what makes it kind of different. And class is not good for injury, because injury severities can change. Mm-hmm. I mean, they can be so different between person to person. Where class, what's going to happen is the attorneys get rewarded for bringing these claims to stop these companies for, being lax with their security measures. And what the individual class members usually will get were, life lock for 2 or 3 years. It's a little different, where an individual who's injured is going to seek monetary compensation.
All right, so personal injury cases, I know Hollis Wright, you all do a great many car wreck cases. So the major difference between a car wreck case versus then a mass tort case?
I'll tell you, the similarity is this. You are individually injured by the act of someone else.
All right.
That's where the similarities are. The difference is this car wreck you're talking about, that car who caused it for 10,000, 30,000 people, all with differing injuries. That's where the difference is again, it's multiple people who have filed individual lawsuits against one company. And what will happen in mass torts is what we call it, is what will happen is you'll start filing these lawsuits, like a hernia mesh lawsuit filed in California federal court and filed in Alabama state court and wherever, all around the country. And someone eventually realizes we can't do this. This is going to be duplicative. You're going to be, different rulings and same depots being taken over. So there's a body called the JPML that you petition to and you say those things. Look, we already have, 20 of these filed around the country in all these different districts. We don't need the CEO to be deposed 20 times. We don't need all these different orders from these different judges that some conflict, some are the same. So we are asking you to create an MDL, multi-district litigation is what they call it. Okay. And we want you to assign it to one federal district. And once that happens, all those cases, no matter where they're filed, will all be transferred under that one judge in that one situation. So you have at least one judge ordering one order. It affects everyone. You have some efficiency. You have everybody under one roof. And the idea is you get everybody under one roof, you get one judge, you might be able to come to a resolution sooner, is the idea.
So you have a couple decades experience with this, so you probably have some good examples. After the break,
sure,
would love to hear some examples of some cases, as many details as you're able to share.
Sure. I'll do my best.
Client-attorney confidentiality. We get that, but let us know on the other side of the break. Give us some details about cases you've been involved with. Visiting with Bo Bell from Hollis Wright. We'll continue this conversation on mass torts, mass tort process, right here on the podcast. Stay with us.
We don't love doing TV commercials, but we advertise so you know there are, in fact, differences in law firms and attorneys. If you're looking for a firm that is up for your fight and never quits, you found us. Let Hollis Wright tell your comeback story. If you've been injured in an accident, trust the local Alabama lawyers who've been helping local people for more than 20 years. At Hollis Wright, our personal injury attorneys are right here in Birmingham and are ready to tell your comeback story.
Visiting with Bo Bell in these amazing offices of Hollis Wright, law firm here on Morris Avenue in Birmingham, Alabama. Are you from Birmingham?
I am, born and raised.
Really? Born and raised in Birmingham?
A little time in Mississippi for college and a year or two of high school, but in law school, actually in Mississippi, but from here.
Here in Birmingham. So historic Morris Avenue is where this the law firm is located. The cobblestone streets of
pretty until you drive down it.
It is. It's a bumpy ride.
Yes, it is.
You got to really want to come to work.
That's right.
All right, we're talking mass torts with Bo Bell. So you've got tons of these cases under your belt. So maybe pick a couple of them, examples of cases.
Like I said, I've been here since 2008, 16 years. The very first case I ever came to was Vioxx, which was this major drug people were taking, non-steroidal, steroidal anti-inflammatory. It got pulled.
What did it do?
It basically, like naproxen, things like that.
Oh, okay.
But it was a prescription strength. And the problem is they found that it was causing all sorts of problems, heart attacks, strokes, things of that nature. And that was like my first start at mass torts because I just started here, the settlement was announced, and there were about 3 injuries you had to prove up. So that was my first. But over 16 years, there have been, I have probably opened, investigated, filed 15,000 cases since then.
Goodness.
I mean, it's a crazy amount because these are, again, mass, so you're gonna have a lot of clients. Some of the ones that right now, we still have the hernia mesh cases. And when you say hernia mesh, it sounds like, oh, that's one case. No, there are multiple manufacturers, and those manufacturers make multiple different hernia meshes. So, these are all different cases. You'll have some that were filed in federal court in Georgia against one manufacturer. You got some in Ohio against one manufacturer, some in Rhode Island State Court, Massachusetts State Court. What those were about mainly is hernia mesh was designed to stop recurrence. You have a hernia, they used to fix it with a suture. They came up with this mesh. This mesh is supposed to, can't prevent recurrence of the hernia, but it's supposed to prolong the chance that it may or may not happen. Problem is the materials in this mesh react very badly when it's inside the body. And, next thing I know, these things are going to start adhering to internal organs. I mean, once this thing adheres to your bowel, next thing you know, you may have to have a bowel resection or you have bowel obstruction. So that's the basis of those cases. You know, I'll have some clients who had it placed and had it removed. They may receive something when it's all said and done, but it's really going to be people who, when they go back in to remove it, they see, oh no, this has, attached to all sorts of things and caused so many major problems. That's probably one. Another one that just recently got announced a settlement, so I'm not giving away anything. The Philips CPAP, that was the CPAP machines recalled. They had this foam degradation that could cause all these injuries. When this was first announced, there was probably a list of like 50 potential injuries that people thought could be caused. But just how these cases work, once the experts work through it, they narrowed it down to about still 20, which is a lot. So that's kind of what we're looking at there. And some of those are going to be, certain types of cancers. And then, of course, you're breathing this stuff in. So a lot of lung problems and things of that nature.
So it sounds like all of those cases are medical device, but this doesn't, mass torts does not have to be a medical device case.
It does not.
Are most of the mass tort cases you've been involved in medical devices? I
am 100% either defective drugs or defective medical devices. But there are, of course, mass torts. I mean, a product could be anything. Exploding pressure cooker, something like that. There could be cases against that if they injured enough people. Some of those are going to be individual because it might not be that big of a scale of people who were injured. But mass torts is not limited to what I do, but it is usually going to be based on a physical injury for the most part.
The examples, like the hernia mesh thing, that just sounds horrible. And in my layman's brain, I think this probably should have been checked out before it gained any kind of approval. So I'm curious as to how did something like that gain FDA approval?
So the FDA will approve a medical device based on two things. One is called pre-market approval. If you go through pre-market approval, I'll say PMA for short going forward, is the medical device manufacturer has to turn over everything. Every little aspect of this device is given. All the clinical trials are shared, how it's going to be manufactured, where it's going to be manufactured, what warnings and packaging. All this stuff has to be given to the FDA to be approved. If you go through that process, you basically cannot sue a product. But there's also another option called the 510K process, and that is going to be basically a grandfathering in. And what the argument's going to be is we've used surgical mesh in the past. This is not new. We don't have to do this pre-market approval process, so they can come out with these things without any clinical trials or anything like that and be allowed to put it out in the general public.
So before we go to break, I'm curious about the types of claims that can be brought against a defective device. Okay. So what are the options there?
On a medical device, you're really kind of looking at three things. Okay. You're going to look at design defect, that the product was just terrible from the beginning. The design was awful. It was going to
So before it ever made it to the manufacturer,
their design was just terrible.
Okay.
And we saw that in a lot of these metal-on-metal hips litigation back in the past. They did a metal-on-metal. They were made out of certain ions, cobalt and chromium, and they just, together, they were terrible. And they failed. It was... The other would be manufacturing defect, where your design's fine, but you manufactured it in such a poor manner, whether it's something wrong with the facility or just a mess up. That's what you're going to do. And then there'll be warnings because the medical manufacturers have to warn about the potential adverse effects. And if you knew something, and unfortunately this comes up a lot, if you knew something and you didn't warn about it or you downplayed it, that could be. And most of my cases is going to have a mixture of some of those. That's basically.
Does it have to be recalled?
It does not.
So they can still be on the market and be a part of a...
The hernia mesh cases that we are pursuing, I think of all the many different products, only one, I believe, one or two got recalled, but the majority are still out there. So no, you don't have to have a recalled device to bring a lawsuit. And the opposite is true. Just because a device is recalled does not mean that, I have a case, I was injured, I won. I mean, you got to see why it was recalled and whether that reason would in any way relate to the injury you're having. And the other thing about that, and I'm probably getting deep in the weeds, is a thing called remedial measures. In most jurisdictions, I can't go, look, they recalled it, therefore they knew there's a problem, because we want to encourage companies and people to make changes to things that if they're worried there may be an issue.
That's a good
and
point.
so I can't go and say, I recalled, my client gets paid immediately. It just doesn't work that way.
Yeah.
So it can it doesn't have to be recalled, and a recall doesn't automatically mean I got a case and I won.
Medical devices are interesting, but it's also interesting, I guess, issues with drugs, defective drugs. Let's take a break, but when we come back, let's kind of dive into that because that's interesting as well, because that's also something you hear a great deal about, defective drugs and adverse reactions to them. We'll deal with that more with Bo Bell from Hollis Wright after the break.
The attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show in 2011, my goal was to do what our firm does best. Help people answer questions related to real-world legal issues they have in their lives in a way that's not intimidating to talk with a lawyer. If the issue is important to you, it's equally important to us, and we're ready to talk with you at no cost.
Yeah, oftentimes people are confronting various legal issues in their lives that really run the gamut of a lot of different legal practice areas, such as bankruptcy, criminal law, civil law, such as personal injury, divorces, domestic relations. And to be able to have a show once a week that covers those practice areas and answers people's questions in those areas, that's really the main objective of the show.
We use the resources of the many lawyers at our law firm to create a plan that has a lasting impact for each person that calls or texts. And we also give back to the community at the same time. We are here to serve you, the viewer, each week on The Attorneys.
Visiting with Bo Bell, attorney here at Hollis Wright, the second longest tenured attorney at this firm. That makes you sound... That's some gravitas right there, man.
Yeah, I say it all the time in my emails. It's my sign off.
It's a great icebreaker for sure. All right, so we've dealt with medical devices relative to mass tort cases, but I also hear a whole lot about defective drugs and the reactions to them.
Sure.
And some of these stories are just horrible.
Right.
So first of all, what is a defective drug? If you were to define that, how would you define that?
It's going to be anything where the risks far outweigh the benefits.
Okay.
That's going to be your short answer. They put it out there and let's say, it was going to help you with some minor situation, and now all of a sudden the adverse results something major. I mean, that's the most simple thing I could say.
All right. Who regulates, approves these drugs before they go to market?
The FDA does. The FDA approves it all.
So they handle drugs and medical?
Yes, they handle everything. Cosmetics.
They're busy.
I mean, yeah. And that's going to be an issue we might get to in a minute about how that happens.
Yeah, that's.
But yes, it's the FDA, they're controlled.
All right. So if a drug is approved by the FDA, is it safe just to assume that it's safe?
No.
Past
Two reasons. One
proves that.
is if the drug wasn't approved, you didn't take it. So good luck with that.
Yeah.
You didn't take it legally. Second of all, if it is approved, no, that's still not going to prove anything. There's so many reasons why that's true. You got these pharmaceutical companies spend a lot of money to make these drugs. So, sometimes there's going to be a rush to the market. Maybe they didn't complete their clinical trials. And the other thing could be they hid things during the clinical trials or, just downplayed them. Then the FDA, because, as I just said, it's not just drugs and medical devices. They do all sorts of things, cosmetics and everything else. They're understaffed. Mm-hmm. So they don't catch everything because what they're reviewing is the information the drug company gave them. Right. They're not doing their own. They're looking at what the drug company gave them as their studies, and they're making decisions based upon that.
They are basing that on the information the company gave them.
The company has to give them all the trials.
So no independent investigation?
Well, I mean, they review the information and the results, and they make sure they think it's, but they're still overwhelmed.
That's very trustworthy.
Yeah. And then the fourth thing will be, you do these clinical trials, you're in a very monitored scenario. I mean, you got, very rigid, take the pill at this exact time. They did get to decide who's in the clinical trials. There might be people with certain issues, medical, issues that were not allowed in. So you might not see these things in the clinical trial, but once it gets out there in the general population and, you can't trust us, you don't know, then things start arising because you're mixing it with something else, or you have some, some health condition that they didn't even consider. But once they start seeing that, they have a duty to tell. I mean, their duty never ends. They have a duty to warn, and they must continue to warn and let the FDA know what's happening.
So that's the responsibility the drug companies have once it goes to market, because you're right, especially it seems like the last 30, 40, 50 years, whatever new diet pill, diet drug, diet whatever, once it hits and becomes popular and takes off, then the demand, you can't find them.
Right.
Yeah.
Exactly.
So then it's all market driven.
Yes, exactly. So that's the problem. Once it's out in the general population, we're not unregistered. We're not as rigid as they are in the clinical trial.
So you're saying some drug companies that are making money hand over fist, they're a bit hesitant to cut that hand off and say, hey.
Yeah. They very much are. I would have to agree with that statement.
Yeah. They're not to rush.
I take prescription medications, and I got to believe that they are helping me. But sometimes they're not always doing that.
All right. So let's hang here on these on the drug cases. So the vast majority of drugs that are dispensed, are they generic? Or
I
brand
think I read
name?
somewhere that like 80% of the drugs that are getting filled are generic.
Okay, 80% are generic.
Somewhere that being filled right now. And the problem with that and where we're going with that, and one of the reasons I wanted to get into that is because people don't know this, you cannot sue a generic drug manufacturer for failure to warn or failure to adequately warn. That was decided in 2011, Supreme Court, Pleva v. Menzing. And basically the reason is that federal regulations tell a generic manufacturer they have no right to change the warning, they have no right to change the chemical composition, they have no right to send out Dear Doctor letters, they can't do anything. They have to be identical to the brand name. So as long as they do that and they don't venture out of that, I can never sue a generic drug manufacturer. Even if that manufacturer knows, and that was what that case was about,
right?
They knew that drug in that case was causing a particular issue called tardive dyskinesia. It's almost like a Parkinson's, but it's only drug caused. But the prescriber, the physician and the pharmacist were giving out the generic version. And because they took the generic, they could not sue, and they lost their case. So it's pretty crazy, and I think a lot of people don't know that, and that comes up a lot in my case. People will call me, hey, I took this, or I see you're looking into this particular drug case. Mm-hmm. And I'll have to look in their pharmacy records, like, can't help you. I mean, you did not take the brand name, you took X.
Right.
There have been ways to try to get around it, but they have not really succeeded. Innovator liability was something people were hoping we could do, where we could sue the brand name, even though you took the generic, because, hey, brand name, like the FDA said, you're responsible for this. You should have changed it. And I believe maybe one state in the union still allows that. Mm-hmm. But drug cases are very, very tough. There are other things you got to consider, too, when people call me like, hey, another big thing is what's called learned intermediary. The warnings for these drugs, prescription drugs, don't go to you and me. They go to the doctor. That's where it stops. The doctor is the one that has to fill that prescription, or you can't have it. Right. So the warnings are not, oh, I wasn't personally warned. No. It's going to be the doctor. Did the doctor know? Yeah. And we depose that doctor if he says, hey, even knowing what we know now, I still would have given her the drug, or him or her the drug, because I still think it benefits her. Right. That could be the end of your case. And which to me, I think it's a little unfair now, because if I read this right, the United States, and I think only New Zealand, allow direct to consumer marketing by pharmaceutical companies, where you're seeing this commercial nonstop. Try to watch a football game. Try to watch anything. Yeah. And it's nonstop, ask your doctor. Yeah. And like I said, not any other country lets that happen. So I think the learned intermediary doctrine should be relooked at. Not my call to make. But I mean, no longer are they, just talking to doctors. They're directly coming to you, and then they get to go back. No. My warning was not to you; it was to the doctor. And as long as he thought it was a good decision, sorry, you don't win.
Before we wrap up this episode, what are you working on now? What's new on the horizon, Mass Tort-wise?
We're investigating a lot of things out there right now. I would say we have not taken anything new. What we still have in house are some cases that we, have been working over the years that are slowly starting to resolve, the hernia mesh cases. Some manufacturers have already settled, and we cleared. There's one big manufacturer out there, Bard. He's got about 25,000 cases still pending for these hernia mesh defects and these injuries that's caused. So we still have a lot of those out there. I mentioned Philips has agreed to resolve, I think it's 45,000 claims for their CPAP machines. So we're working through that. That was relatively new. That process hasn't truly started yet. And then last year we had seen a resolution to the combat earplugs. Okay. These were the earplugs that our veterans use that were defective. Many people have already received their refunds, but that's still ongoing, where some people are still waiting. So that's kind of where we are right now. I still keep looking to the horizon to see what's out there. I try to be picky on what I choose, and because there's some of the things I talked about, there are pitfalls potentially. So I got to investigate and go, where do I think this is going? You know, is this company solvent? Is this company, even a U.S. company, you know, are the injuries so prevalent that I can prove this up when it needs to be done? So, you know, right now, nothing particularly new, but that always could change tomorrow.
Yeah. And if you all are taking on a case, all that information, I guess, would be on your website.
Oh, absolutely. It gets put on the website immediately. You know, we'll put our advertisements forward. We'll email our people who follow. We'll talk about it in shows like this. And on the attorneys, we'll get the word out for sure.
Hollis-Wright.com, or you could give them a call.
Absolutely.
888-LAW-TALK.
Yep.
Bo, it's good to see you, man.
You too.
Thanks so much for the time learning about mass torts here, right? I feel like an expert myself now. All right.
Do it for me next time.
There you go. No, please no. You're not. The client would not want that. Hey, but we do appreciate the time. Thanks so much to Bo, and thank you for listening in as well. We'll see you next time.